This presentation will discuss remedies available in an unfair dismissal claim and how to draft a schedule of loss. First of all, when will an employment tribunal deal with remedy? This varies case by case. Sometimes they deal with it at the end of a full merits hearing, and other times it's deferred until a later date, i.e. listed for a separate remedy hearing. The important thing is to attend your full merits hearing with all the relevant evidence that you need to enable the tribunal to make a decision about the remedy in case you're successful in your unfair dismissal claim and they decide to deal with remedy there and then. The Employment Rights Act 1996 sets out the possible remedies where an employment tribunal has found that an employee has been unfairly dismissed. These are a financial award made up of a basic and compensatory award, or reinstatement or re-engagement. If a tribunal decides you have been unfairly dismissed and orders a basic award, you will get compensation, which is a fixed sum and calculated using a statutory formula. You may also get a compensatory award, which is generally to compensate you for money you've lost as a result of losing your job, for example, your lost salary. How to calculate these two awards will be explained later on. The ET1 claim form has a section where you can include the remedy you are seeking. There are boxes you can tick to say if you are seeking re-engagement or reinstatement, or, in the alternative, financial compensation. There is no space to set out more detailed calculations. It is optional to complete this section. Case management directions may require you to produce a document setting out what financial remedy you are seeking, including how it's calculated. This is called a schedule of loss. You should ensure that you do this by the date set by the tribunal. There are potential serious consequences to not complying with tribunal directions, which can include, for example, part or all of your claim being struck out or having to pay the other side's costs. If you're not ordered to produce a schedule of loss, it is still useful to produce one, as it's a clear way of presenting the potential value of your claim to the other side and the tribunal. This may come in particularly useful at a remedy hearing, but also in the lead up to a hearing, for example, if you're engaging with the other side directly or via ACAS in discussions about settling your claim out of court. If you can show the other side how you've come up with this figure you're seeking, this can sometimes assist in negotiations, as it shows you've not just plucked the figure out of thin air. I will explain how to produce one of these later on. Looking at reinstatement and re-engagement in more detail then. You have the option to request that the tribunal consider granting this type of remedy. Reinstatement means that your employer is required to give you your job back, and re-engagement is when your employer re-employs you, however, in a similar role. It's important to note, both of these remedies are rarely granted in practice, being made in less than 1% of cases. It is also not a remedy that is often sought by employees, because it may be the case that an employee would not wish to go back to work for their old employer if they were unhappy about the way their relationship ended. Bearing this in mind, the tribunal will take into account the wishes of the employee, whether it is practical for the employer to give the employee their old job or another job back, and the feelings of both parties when deciding whether to order these remedies or not. An order for reinstatement or re-engagement cannot be made in addition to a basic and/or compensatory award. However, if one is made and the employer refuses to comply with such an order, the tribunal will make an additional financial award, as well as making an order of compensation for an unfair dismissal. I will now explain the process of calculating the value of your claim if you're seeking financial compensation instead of, or in the alternative, to reinstatement or re-engagement. There are several documents that are helpful to include in the trial bundle to help you produce your schedule of loss and demonstrate to the tribunal that the calculations in your schedule of loss are accurate. This is particularly important if the other side are disputing the figures you've come up with. The types of remedy-related documents that might be helpful to include in the bundle are recent payslips, your contract of employment showing your salary, pension and entitlement to other benefits, for example, private medical cover or life insurance, and any letters confirming, for example, pay rises. Any bonus policy documents, if relevant, evidence of job searches you've conducted since you were dismissed, for example, online searches on recruitment websites, evidence of job applications you have made since being dismissed, and any acceptance or rejection letters received. Receipts of travel to the job centre or interviews in your search for new work. Stationery costs for sending application letters. The above documents can help show what financial losses have resulted from you being dismissed by your old employer. If some of the documents to support your old calculations are still with your employer, you can ask them for copies. If they refuse, you can ask the Employment Tribunal to make what is called a disclosure order, requiring the employer to produce the documents. The Tribunal has the discretion as to whether or not they make such an order, so to encourage them to do so, you should write to them explaining what documents you require copies of and why these documents are relevant and necessary to support your claim. You should also send a copy of your letter to the other side, as they are entitled to comment on your application. I will now explain how to calculate a basic award. First of all, work out the length of time you were in the job until the date you were dismissed. You can only count complete years. Next, work out the age multiplier. This applies to you throughout the length of service. The age multiplier may change depending on how old you were throughout your employment, so we need to look at the categories. The age multiplier is split into these three categories. 1.5 weeks pay for each year of service for an employee aged 41 plus at the beginning of the year. 1 week's pay for each year of service for an employee aged 22 to 40 at the beginning of the year. And 0.5 weeks pay for each year of service employed aged below 22 for any part of the year. Once you have the age multiplier, you then multiply this by your length of service at that age, and then multiply this by your gross weekly pay. Your gross weekly pay means what you were paid before tax and national insurance deductions. It's important to note here that there is a maximum amount that can count as a week's pay when you are doing the calculation. If your gross weekly pay is more than £544, you can only claim up to £544 per week. This amount applies if you were dismissed on or after the 6th of April 2021. If you were dismissed on or after the 6th of April 2020, the amount is £538. This statutory cap on gross weekly pay goes up in April each year, so do check the figure before you complete your schedule of loss. You cannot count more than 20 years of employment when you are doing the calculation, even if you have worked for the employer for longer than 20 years. If you are on furlough and dismissed on or before the 31st of October 2020, ignore the fact you were on reduced pay during a furlough period when calculating the basic award. So let's break this down into an example. Say you were 42 when you were dismissed, had completed 5 years, and your gross weekly pay was £450. For 1 year of employment, you were aged 41 or over, so the multiplier is 1.5. The calculation is 1.5 multiplied by 1, as it was 1 year of service at that age, multiplied by your gross weekly pay, which was £450, equaling £675. For the other 4 years, you were in the age category of 22 to 40, so the age multiplier is 1. The calculation is therefore 1 times 4 times 450, equaling 1,800. Then you just add the amounts together. So 675 add 1,800, and your basic award in total would be 2,475. This is another example. The difference here is that you are capped if you earn over 544 in gross weekly pay. So keeping the other factors the same as our previous example, but now your gross weekly pay is £600. The calculation would be 1.5 times 1 times 544, equaling 816, plus 1 times 4 times 544, equaling 2,176. So your basic total award would be £2,992. Moving on to possible reductions to the basic award. Section 122 of the Employment Rights Act allows for the Employment Tribunal to reduce your basic award in certain circumstances, such as if the tribunal thinks your conduct was at fault before your dismissal, the Employment Tribunal has discretion to apply potentially up to 100% reduction. If there is a receipt of statutory redundancy pay, essentially the way you calculate redundancy pay in the same, so you cannot receive this money twice over, or if they believe you unreasonably refused reinstatement, meaning your employer offered you your old job back and you refused to return to work. However, this depends on reasons for your refusal and the circumstances of the dismissal. In relation to point 1, the tribunal would have to be satisfied that you were guilty of misconduct and that this conduct was bad enough to justify reducing your award. The conduct might be the conduct relied on by the employer to dismiss you, or conduct that has come to light after your dismissal. Examples of conduct which might be bad enough to reduce your award would be things such as stealing from your employer or deliberately breaching health and safety rules and putting colleagues at risk. You do not need to include reference to 1 and 3 in your schedule of loss, but just be aware that these might potentially be applied at a remedy hearing. After the basic award, the Employment Tribunal will consider a compensatory award. As I mentioned earlier, a compensatory award's objective is to compensate you for what money you have lost that flows from your dismissal. However, it is not to award a bonus. The amount will be what the Employment Tribunal finds to be just and equitable. How to calculate a compensatory award. When calculating the compensatory award, there are several losses you may include. Starting with point 1. You should include the loss of wages between your dismissal and the hearing where remedy is going to be decided. Be sure to include any regular overtime you would have usually undertaken, pay rises, car allowance, bonuses, etc., if applicable. Next, point 2. Calculate your future loss of wages. This means how long you think you should be compensated for. For example, how long do you think it will realistically take you to find another job that pays the same as your old one? The tribunal will consider an appropriate cut-off point for future losses, depending on factors such as your health, age, skill set, or other reasons impacting your ability to secure other work. For example, labour market conditions. If you found a new job at a lower wage, then include the difference, except during your notice period in circumstances where you did not work your notice or got a pay in lieu of notice. For example, if you had a 2-month notice period but were dismissed on the spot and got a new job 1 month later, you would state your wage losses as your full previous wage for 2 months, but after your notional 2-month notice period has expired, your ongoing losses would be the difference between the wages in the job you were dismissed from and the wages in your new job. Moving on to point 3, you should add in the loss of protection in respect of unfair dismissal. What this means is that it will take you 2 years in a new job to build up the right to claim for unfair dismissal and the right to a statutory redundancy payment with a new employer. The court recognises this with a token payment. This is usually calculated at around £300, but this is not set in stone. Point 4 is that you should calculate your loss of pension right. For example, the percentage of your salary your employer contributed each month, and other benefits you may have missed out on, such as private medical insurance or life assurance. To calculate the loss of benefits, you could potentially research the market and include examples of how much it would cost to replace the benefits yourself on similar conditions with supporting documentation included in the trial bundle accordingly. Point 5 is in relation to costs relating to reasonable job expenses incurred, for example, the cost of travel whilst looking for work. Finally, point 6 refers to any losses you should be compensated for in terms of for attending interviews and the job centre. Make sure you include receipts as evidence. Once you've worked out how much your compensatory award may be, you need to look at any reason why a tribunal might reduce the amount you receive. Some of these points will be explained further over the next couple of slides. The order of potential reductions is applied as followed. First, the award may be reduced by any sums you have received since you were dismissed, from a new job, if not already included in your calculation, and or to reflect a failure to mitigate your losses. Second, there may be a bulky deduction. This would reflect any chance that you'd be dismissed anyway, even if your employer's procedural errors were corrected. The next point is a percentage deduction if you fail to comply with an ACAS code of practice on discipline and grievance procedures, or potentially an increase if your employer failed to comply. Point 4 is a percentage reduction to reflect any blameworthy conduct contributed to your dismissal, up to 100%. Number 5 is to account for any enhanced redundancy payment that exceeded your basic award. Finally, there may be a statutory cap applied to your award, and you will need to give credit for any state benefits received, such as employment and support allowance. We recommend you include reference to earnings from a new job, point 1, enhanced redundancy pay, point 5, statutory cap, point 6, and state benefits, point 7, within your schedule of loss calculations, as employment tribunals will almost certainly look to make these deductions from any compensatory award. You will not need to include reference to points 2, 3 or 4 in your schedule of loss, because these are arguments to be made by your respondent, not you, and the deductions will not apply in every case. However, it is important for you to be aware that the judge may consider making deductions of this nature. You may be asked to put forward your views at the remedy hearing of any allegations made. For example, allegations of you not making sufficient attempts to find other work, or that you contributed in some way to your own dismissal, such as by not turning up to a disciplinary hearing. Try and think before you attend the hearing what you want to say in response to such allegations, and where possible, seek to include documentary evidence to back up your point of view in the trial bundle. To expand on a few points I made on the previous slide, in relation to point number 1, you, the claimant, are expected to make reasonable efforts after your dismissal to keep your losses to a minimum. This is called mitigating your losses. This means doing things such as actively looking for, and if offered, taking another suitable job, as well as applying for available state benefits. In other words, you can't just sit back and wait for the Employment Tribunal to make an order for the employment to pay up. What constitutes reasonable steps will depend on the facts of your situation. This means the tribunal will take into account your skill set, your age, your childcare responsibilities, and the current job market and other factors of this nature in order to assess this. It is for your old employer, the respondent, to prove you were unreasonable in your approach, but you should produce evidence to show what steps you took, for example, by including evidence of job applications in the trial bundle. This slide explains point 3 in regard to following the ACAS code of practice. An employment tribunal may decide to increase your compensatory award if your employer did not follow the ACAS code of practice on disciplinary and grievance procedures. For example, unreasonably delaying meetings or decisions, not investigating the issues properly, not allowing you to be accompanied to a disciplinary meeting by a colleague or trade union rep, not holding a disciplinary hearing, or not letting you appeal your decision, and or did not give you a written statement of your terms and conditions of employment. You should specifically request this increase from the tribunal if you think it applies to your case. The tribunal could potentially increase your compensatory award by up to 25% for this failure. The maximum percent increase is usually reserved for cases where your employer didn't follow any procedure at all, without good reason. If your employer has followed some kind of procedure, but hasn't met with all the requirements of the ACAS code, the tribunal is likely to award a smaller increase, for example 10%, depending on what they failed to do. Note that this increase or decrease doesn't apply in redundancy unfair dismissals. Also, if your employer thinks you did not follow the ACAS code, for example by not attending a disciplinary hearing, then they may ask for a deduction to the compensatory awards. There will be a link provided in the description of this box which provides a copy of the ACAS code from their website and sets out the requirements of the code in more detail. After you've assessed how much your compensatory award may be, you need to work out if it falls below the maximum amount of the compensation that a tribunal can award. There is a current statutory cap on compensation awards for unfair dismissal set at £89,493. This means you will not receive more than this amount, even if your gross pay for a year is higher than this amount. If you earned less than £89,493, there is still a cap on the amount you can be awarded. This limit is 52 weeks gross pay. A tribunal can't award you more than this, regardless of how much you've worked out your claim to be worth. These limits apply if you were dismissed on or after the 6th of April 2021. If you were dismissed on or after the 6th of April 2020, the compensation cap is £88,519. The limit goes up in April each year, so please be sure to check the current statutory cap online before you draft your schedule of loss. The statutory cap does not apply when brought in the following claims: unfair dismissal for carrying out health and safety activities, Section 100, Employment Rights Act 1996, unfair dismissal for making a protected disclosure, whistleblowing, Section 103A, and selected for redundancy for carrying out health and safety activities or whistleblowing, Section 105. The Employment Tribunal may have issued a list of issues, case management directions, or notes of a preliminary hearing, which may include reference to what specific types of claims you have brought. Refer to these documents to help you check if you've brought a claim where the statutory cap does not apply. I will now provide an example of a schedule of loss to talk you through how to ideally set one out. As previously mentioned, a schedule of loss is a document setting out how much you think your claim is worth. It should demonstrate your calculations for both your basic and your compensatory award, which we talked through earlier, reflecting what you wish to be paid by the tribunal if you're successful in your claim. There's no set document for a schedule of loss, but you can use the blank one from Citizens Advice. The link is in the description. Their website is also a good place to generally find out information about how to calculate an unfair dismissal remedy. So, to begin with, you need to put your name in the box which says name of claimant. Underneath that, put your employer's name under name of respondent. Then you need to fill in the section called details. First of all, write your net weekly basic pay. This means your actual take-home salary every week, so what you're paid with national insurance and tax deducted. If the amount varies, take your average pay over the 12-week period leading up to the date of your dismissal. It can be more complicated to calculate your loss of wages if you have irregular working hours, and in this circumstance, we particularly recommend you seek advice on how to draft your schedule of loss, for example from Citizens Advice. In this next box, you need to put your contractual notice period. This is the amount of time written in your contract that you had to work as an employee before you could hand in your notice and leave the company. Remember to put whether this was in weeks or months. Next, write your date of birth. Where it says period of service, write the date you started your employment to the date you were dismissed. Here, Fill in the amount of continuous years that you worked for your employer. In this next box, you need to put your age at the date of termination, what we call the EDT. Your age the day you were dismissed. For this section, fill in your gross weekly basic pay. So that is the amount you were paid per week before tax and national insurance were taken out. Here, fill in the date of your remedy hearing. Finally, if you've gained employment since being dismissed from your old job, you'll need to fill in these 3 boxes. The date you started your new role, your net weekly basic pay in the new role, and the total amount earned in the new role up to the date of the hearing. To calculate this, multiply the net weekly basic pay in the new role by the number of weeks you've worked in that role. So, in our example, we will have worked 4 weeks in our new role since being dismissed. So, times 4 by £240.10, and this equals £960.40 earned. This amount will be deducted later to show your mitigation. The next section is where you state your basic award calculations. I explained how to do this in more detail earlier, but just to recap, you must put in the relevant age multiplier multiplied by the number of years of service multiplied by the gross week's pay. And remember, this is subject to the current statutory maximum of £544. So, for example, here we would multiply 1.5 times by 6 years times by £315.02, giving us the total of £2,835.18. If you received a statutory redundancy pay, you must write this under this heading, and then deduct this when calculating your total basic award from the calculation. Here, I've imagined that this unfair dismissal case did not relate to redundancy, so the reduction here is 0. Therefore, this gives us a total of £2,835.18 for our basic award. In this next section, set out all your calculations for your compensatory award. The first losses we calculate for this, under 3.0, is the losses from the date you were dismissed until the date of your remedy hearing. In this first box, you must write in your loss of basic salary from the date you were dismissed from your job up until the date of your tribunal. This can be calculated by multiplying the number of weeks there has been between your ETD and the remedy hearing with the net weekly basic pay. So, for example, in this case, there would be 43 weeks. So 43 multiplied by £315.02 equals £13,545.86. Next, fill in your losses from any statutory rights. These are usually calculated at around £300. Where it says 3.2, fill in any loss of commission or contractual bonuses from the date you were dismissed until the date of your hearing. Here, I've imagined the person does not do a role where they receive any commission or bonuses. For 3.3, write in your loss of any pension from the date you were dismissed to the date of your tribunal. This might be a percentage contribution of your salary your employer made each month. For example, 3%, which is the figure we've used here. Most employers must now contribute to a pension fund for their employee unless the employee has specifically opted out. So here in the example, we've done £9.45 times 43, giving us a total of £406.35. Then for part 3.4, state the amount of loss for any other benefits from dismissal to the date of the tribunal. As previously mentioned, the figure you insert here may, for example, be the monthly cost of replacing any private medical cover your employer used to provide. We have included a figure here based on the average cost of private medical insurance, but you ideally need to obtain quotes for private medical insurance providers that reflect more accurate costs for someone with your particular circumstances. So here we times £29 by 43 weeks, giving us a total of £1,247. Finally, for 3.5, fill in the amount of any expenses incurred from dismissal to the date of tribunal. For example, have you spent any money on bus tickets, petrol, stationery, printing to help with your job search? Here, I've imagined the employee has receipts for up to £25 of job search related expenses. Then add up all the amounts and put a total under the heading Past Total Losses. Next, under the heading Deduction of Sums Earned by Mitigation, we need to write down anything that needs to be deducted from the past losses. So, if you received a ex gratia redundancy payment, fill in that amount, and or if you received any sums obtained through mitigation to the date of tribunal, for example, a salary from a new job, also write that down. Then add these together and subtract them from past losses to give you an amount for total past losses. As you can see, in our example, we earned £960.40 from our new employment after dismissal up to the date of the hearing, and therefore we must subtract this from our past losses, giving us a total amount for past losses of £14,563.81. If your new role comes with benefits that you are claiming in relation to, for example, pension contribution or private medical insurance, you should reflect this in your schedule of loss. Here we've imagined the claimant's new role did not come with the same benefits package as her old role. The next section is your calculations for potential future losses. First of all, you need to fill in the amount for future loss of earnings. You can do this by multiplying the period of time you think into the future you should get paid by the net weekly basic pay from your old role. For example, this claimant believes that realistically it will take them 18 months from the date that they were dismissed to secure a job with at least the same level of pay and benefits as their old job, due to factors such as their age, skill set and the job market in the local area. This takes the claimant to 33 weeks after the remedy hearing. So, we have multiplied 33 weeks by the net pay in her old role of £315.02, giving us a total of £10,395.66. Then do the same for your future loss of pension, your future loss of other benefits, and future expenses in a similar way to how you calculated them in the past losses section, and calculate a total. Next, under Deductions of Sums Earned by Future Mitigation, work out any future mitigation. For example, earnings and benefits from any new role obtained for the same period of time you're claiming losses for. Then subtract your future mitigation from your total future losses and put this figure in the amount for total future losses. Next, we need to calculate your overall total losses. For this, add your total past losses, so in our example £14,563.81, add your total future losses, £3,751.21, totalling £18,315.02. The next section to fill in is the total loss and adjustments. Remember, if your employer unreasonably failed to comply with the ACAS code, then you can multiply this amount by up to 25%. Here, I've imagined the employer failed to follow some of the procedural requirements. For example, they forgot to allow me to be accompanied at my disciplinary and appeal hearing, so I've suggested an increase of 10%. This gives us a total of £20,146.52. Under Section 4, write in the amount for any enhanced redundancy payment in excess of the basic award, if applicable. Here, we're using an example where it is a dismissal not related to redundancy, so the figure is 0. If you had no enhanced redundancy payment, then the total compensatory loss will be the same as the grand compensatory award. Finally, if the amount exceeds the statutory cap, 52 weeks pay, or 88,515, as we were dismissed before the 6th of April 2021, Then fill in the maximum statutory amount. Here you can see in our working example that the statutory cap does apply, as 52 weeks gross pay would be $19,864, which is lower than the total compensatory loss we are claiming. The statutory cap is therefore inserted into our schedule here. Finally, we add the basic award and the compensatory award together to give a total value of the unfair dismissal claim. As you can see, our total award in this example would be £22,699.18. We hope this video providing an overview of how to calculate remedies in an unfair dismissal case has been useful. If you're unsure about how to complete your schedule of loss, we recommend you seek legal advice, for example from Citizens Advice.